Hey guys, let's take a look at this Jane Doe versus Marilyn Manson lawsuit that was filed in New York a little more closely. Not particularly the language of the lawsuit, but just what it is. Yesterday, I just read through it with you for the very first time, just skimming through it. Obviously, it's kind of straightforward in terms of the story, but then on second reading, it gets more complicated in the story, and also there are some legal issues in the lawsuit. We'll look at least what a few of those are. This is the most serious case, perhaps, that Manson has faced, and why say that? Well, in the other cases, there's the issue of did the things happen? And in some cases, Manson concedes, yeah, some of that stuff probably did happen. But there's this additional issue, obviously, of was it consensual, right? So that makes the whole thing murkier in terms of alleging it and fighting against it, right? But those are two discrete things. And here, at least in part, consent's not a second option. So it's did the things happen or not, because this involves conduct with a minor. They can be very problematic from a legal perspective if they're not of an age where they can legally consent. So I think that makes it very serious. I think even Manson's fans would concede that this kind of allegation coming out, conduct with a minor, is considered more serious than, say, conduct with a consenting adult, somebody who's well of age and that sort of thing, or somebody who there was an adult consensual relationship with. So that makes it pretty serious. Now, the question of did he do it or not, that is always a valid question, right? You don't throw that out just because the allegations are more serious or more terrible. In fact, maybe it becomes more important then. So whether something's very minor or very significant, the question of did the person do it, that's always a fair question. And if you didn't do it, always a fair defense. This case has the benefit of, even while it has lots of complications and is a long time ago and stuff, is she says he did this to her. And then Howard King has come out, at least from what I've seen, in a statement to Rolling Stone and said, this is untrue. Manson doesn't even remember ever meeting her, but certainly didn't have intimate relations with her. So on the main issue of the fact of did he do this conduct or not, he has said, no, I have not. So there's no issue of, well, I did it, but it was consensual, which there could be, in other types of situations. Here, there's a factual showdown that everybody can understand at least, which is he did it or he didn't do it. Now, if Howard King is correct, and Manson never had any sexual contact with this intimate contact with this person, then her lawsuit has a lot of falsehoods in it. It's bogus, right? But if it's not true, what King is saying, and Manson did do these things, then Manson is lying to his attorney as well as to everyone else about what he did. And if he's going to lie about the fundamental issue of that, then you can suspect he'd be lying about other things too. So that makes this, to me, the operative issue here, which of course it naturally is, which is, did he do it or not? And here he's not mincing words. He's saying, I did not do it. So I think I know how a lot of people stand on that. And evidence remains, of course. There's just a complaint filed. That's allegations. It's not really evidence by itself, unless maybe it's verified or whatever. But I mean, not get ahead of myself. It's a pleading. She's made allegations in the complaint, and she will then bring up evidence to support those to the degree she can. And then Manson will bring up evidence to rebut that to the degree that he can. And when you see all that evidence, you can make a judgment. But for now, the parties' positions are clear. Her and her attorneys are alleging he engaged in sexual contact with her of an intimate nature, and he's saying he did not do that. And then everything else, I think, stems from that pretty much. So let's go over some of the issues in this case, some of the legal things, and then also some of maybe the factual narrative a little bit more. So how can she bring this suit, right? This is a long time ago, which is true. Well, I think probably most people know, like it or not, and some people do and some people don't, states around the country have been passing legislation to extend the statute of limitations periods for sexual assault, and in some cases passing these temporary windows of, say, 1 year that revive very, very, very old claims. And New York has done that. They passed that law and it went into effect around the end of November last year. So before that, she probably couldn't have brought these claims under statute of limitations as it existed. But this window opened around the end of November, and now she has filed this lawsuit 2 months later. So some people are seeing that as no coincidence that these other suits were falling apart and she files now. I'm not going to say that's wrong, because how do I know? But I can say she really probably couldn't have filed this suit before November because she couldn't have brought it, at least in New York, under the old statute of limitations. So they brought it within 2 months of the law changing. Whether that was planned or reactive to anything else, how would I know? But that's how she's able to do it. It's because this window has been opened. I mean, I've seen that happen in North Carolina, and it's happened in other places. like any kind of change in procedural and even substantive law, it's not inherently good or bad necessarily. It can lead to more justice in some cases and more abuse in others. Whatever, New York has passed that law, and that's what's affecting the situation here. But how come she's not using her name? Why is this anonymous? So she has applied to the court to be able to be anonymous at the time she filed her complaint. I haven't seen the order entered on that, but I have seen the proposed order for it. And they give the court reasons why they think it's appropriate for her to be anonymous at this stage of litigation and however long it needs to be that way. And that is issues surrounding sexual assault that can affect the victim in terms of humiliation or embarrassment and things like that. But also she alleges concern for safety, and she says that she's been threatened and is threatened by the defendant Manson and his many fans. So that's what she's telling the court. And that's a little bit similar to what Jane Doe did in California. And Jane Doe has prevailed there. And I think this one will too. She'll be able to proceed anonymously. That doesn't mean Manson doesn't know who she is. It just means they can't go out telling people who she is. And as they move through discovery, they can't identify her necessarily. I'm sure there'll be a confidentiality order entered in this case. Again, similar to the one in California. At least that's what I would think. Every state has their own procedures. So what's different about this case? So this has allegations involving a person under the age of consent, not just a minor for alcohol or whatever, but under the age of consent for sexual activity. That's different. It's legally different and it's morally different depending on where you stand on that. But it ain't the same as having sex with a peer adult. And does this lawsuit engage pedophilia or not? It alleges it in the lawsuit, and we'll take a look at that. We're not going to skip over the hard stuff here. And I think what's different here is there's a serious attempt to bring in these third-party defendants, particularly the record labels. A serious attempt. A lot of the allegations you see about the flyers, some of the stuff about the lyrics and things like that, you're like, oh, they're just trying to pin Manson with that. Well, certainly they want to make him look bad with that. But a lot of that is driven because they have claims against the record companies. The record company didn't do this stuff to her. So she's trying to show, but they knew that it was probably going to happen, and they facilitated the environment where it could and would happen, helped lure her into it, helped create the environment where that type of behavior was protected, and they had plenty of notice about it. That's a lot of what that's about, because they're trying to hammer them in here under some causes of action we'll look at. What are the causes of action? So you probably know by now, a lawsuit, you show who the parties are and how the court has jurisdiction over them, what the what the lawsuit is about and why that court has jurisdiction over that. And you set out a factual predicate, and then you tell the court, these are the legal theories that I think entitle me to relief from you, Judge. You should allow my lawsuit to proceed to judgment because I have these recognized legal theories, and she has 5 in this case, and none of them are novel. You've heard of them all. The first is sexual battery by Marilyn Manson. She alleges, remember, he denies. She says this occurred at age 16 and 19. It's interesting because I think at 16 it was in Texas and maybe also Louisiana. At 19 different places, some of it in New York, and I think that's how they captured New York and for the forum for this lawsuit so far. And then they have a negligence claim against everyone but Marilyn Manson. And remember that everyone else is 2 record companies and then 1 through 20 anonymous defendants. She doesn't know the names of these people yet, she says. And that, as I just mentioned, centers really on notice of the record company of the potential for this type of underage bad behavior to occur by Manson, she says, and that they knew it, profited from it, didn't try to discourage it, instead helped create the environment and the circumstances where that could happen, tried to hide it, she says, that sort of thing. Negligent supervision and retention is the third cause of action. And there they're saying Manson was employed by or an agent of the record companies, and he was under their supervision and control. So they failed in that regard and owed a duty to her as she was a consumer of their product. Then they have intentional infliction of emotional distress to all defendants. And everybody here probably knows by now, you've got to have extreme and outrageous conduct. In New York, that is a pretty tall banner. Might talk about that if we have time a little bit later this week in another stream, because New York has thrown out even a Me Too case where somebody was pressuring, a 50-some-year-old guy was pressuring a 17-year-old woman for sex in order to help her with her music career, and was doing, she says, lots of harassing things, and they threw it out and said that's not enough. So interesting. That's maybe the toughest I've seen. New York general business law, that's the 5th cause of action. It's everybody but Manson, and saying that they engaged in misleading and deceptive conduct, and most states have some kind of statute that prohibits corporations and entities and people from doing that sort of thing under penalty of getting sued. So let's hit the elephant in the room, and that's the underage issue. And the complaint has a lot of mentions of pedophilia in it, symbols of pedophilia, how it was used, allegations of it. Again, whether somebody did something or not, that's always important. But when it comes to the issue of kids and consent, no. And I get pedophiles try to use social narratives to assist them in what they do, from using church and religion to adult sexuality movements. Some of that's current today. Some of it maybe back when Manson was coming up in his career. Pedophiles go where they can get access to the kids and have the kind of control they need to do what they want. But no, pedophilia is terrible. And I think if you embrace essentially the plaintiff's narrative and trying to defend Manson by saying it's not so bad, you don't want to, well, you do what you want to do, but that doesn't persuade me. Because my stance is I'm in the wood chipper or jail remedy for pedophiles. And since the Constitution of society prefers jail, that's the tool we have. But I could see maybe having sympathy for somebody if they have that proclivity, they struggle with it, they fight against it, they don't act on it. But the moment somebody crosses that line and does something with a kid, I have no sympathy for them. And if that is how God made them, then that's how God made me. I have no sympathy for it. Absolutely none, because they are willfully harming and potentially destroying a child's life for their own gratification. They're making a choice to do that. Not everybody has to do everything that they want to do. No sympathy for it. Kids don't consent to sexual activity. I don't care whether you think they enjoy it or they don't enjoy it. No, absolutely not. Absolutely not. Now, having said that, while it's all in the complaint, does this complaint really involve pedophilia? And, I've gotten some comments back from this, which I think are really good points on this. And I say the answer is it does not, at least not as it is set out in the lawsuit. Because pedophilia is usually defined as a sexual desire towards children who are prepubescent. Unless I missed it, I don't really see that kind of either. Well, obviously, I don't see that kind of activity in this lawsuit, and I'm not sure that I really see even where it's going for that. Having said that, she's not making all this up. I mean, Manson was using that as kind of a hook in his early parts of his career, the stuff about kids. And I mean, he's using the word pedophile sometimes himself, and that gets thrown in here. Well, that doesn't decide whether it was going on or not. What decides whether it was going on or not is whether it went on or not, right? And so even if what she said is true here, that's not really a pedophilia situation per se, because of the definition of it, prepubescent. They have other words, if you like kids that are just at puberty, or if you like them just slightly after puberty, they have other words for that. But pedophile, I think in the public mind, though, I agree with Manson's fans here, captures pretty much the range of that. People aren't usually technically defining it like that. So they see it as a great slur against Manson. Yeah, it is. It's a slur against anybody that it comes up against. And it may be true and it may not be true. But I think from a technical level, it's not what happened in this case. Now, that isn't getting to whether it's right or not. We're still not done with this. We're just talking about the use of the word pedophilia as it applies to the allegations of what happened to the plaintiff in this case, who said she had just turned 16 at the time of the original encounters with Manson. So one argument is, hey, it happens all the time, man. It's Hollywood and entertainment. I mean, look at all the rock stars that have done this to girls that age or even younger. And I'm going to concede that one too. First, I conceded your first argument that this really isn't pedophilia. And I'm with you. I agree with you on that one. I'm going to concede this one in terms of it being accurate, but I don't agree that it affects this case. Because even though that's true, and you can rattle off all the names and all the things that happen at Wild Rock stuff, and it still happens, I'm sure, all the time in entertainment today, it doesn't make it right. I think the entertainment industry out there probably is a cesspool of grooming and abuse. Not all these stories are all fake. They just aren't. Other places have been cesspool, and probably still are, of grooming and abuse. I mean, come on. Think about when kids were abused by church figures, and originally thought, well, that was rare. And then unfortunately, it turned out to be a lot more prevalent than originally hoped for. Well, the fact that it happened more than we originally thought, that doesn't make it less wrong. It means it's more of a disaster. So if other people have done it in Hollywood, that to me works legally about the same excuse if you get pulled over and say, why'd you pull me over for speeding? Other people are speeding too. It's not really a legal defense, okay? And I don't think it makes it, if it is bad, less worse. That's my opinion. Maybe if the law cracked down on this, there would be less of it. Who can say? And I've also seen people say, and the third argument here, which is 16, it's not really an issue. And I hear what you're saying there, okay? I get that. People can be naturally sexually active at that age. You're not talking about a prepubescent kid here. You're talking about a teenager. And As long as you've been a teenager, then you already have been one and you kind of know what that's like. And if there were a true line in the sand of at this age, you're a minor and you can't consent, and at this age, you're not, and it was truly the right universal decree, we wouldn't have different years in different states, right? Everybody would just know what that is. But different states have different years. And so there is a gray area there of when does it become right or wrong in terms of the law. And therefore, I agree with you if you say, well, just because it may have been legally wrong in state A and not wrong in state B, that means it's not inherently necessarily morally wrong, right? Those two things don't go together. The law can allow something that's terrible morally, and it can forbid things past the point where people morally care. Come on, there's a lot of that. You can drink yourself into oblivion. You can't smoke marijuana. You can smoke marijuana, but just this much and only in this state. It's a mess, right? So they're not always necessarily the same. But I think you have to admit you're on a razor's edge here, right? Because what I looked up was she was underage, at least in one of the states I looked up at the time. She alleges this stuff happened. So if it occurred, it's legally wrong. And when you're in a legal proceeding, being legally wrong is a bad situation to be in. It's not the case in what happened in these other cases. That's why I think this one is so much different, is the allegation she was under the age of consent. She also alleges the sexual conduct was not consensual. And that, especially when she's older, is subject to the same kind of disputes that occurred in the other cases. But when she's under age of consent, that's a big problem. So I've agreed with you on your first argument. I'm neutral on the second. On this third one, I'm going to part company from you here, respectfully, understanding what you're saying, because I understand it could be 15, 16, 17. Who really knows what the right year is? But I'm just going to say I think it is legally wrong, and I think it is morally wrong for these people that are a decade older to use the position of money and celebrity and infatuation that these kids have to have sex with them or do things with them like that. I just don't think that's right. To me, that is morally wrong. If I were sitting on a jury and the person were accused of that and shown to have done it, they would be behind the eight ball in my book. And also, particularly, it's not like you just lived out in the country and the only other person you knew was a 16-year-old girl, and it's the only possible relationship you could have. I think it's fair to say probably Manson at that point had women throwing themselves at him, and stay away from them, therefore, the kids that are underage or even close to it. Just don't do that. And if you did do it, you may have a tough time in court, legally and morally. But I understand if you disagree with me on that point, I'm just going to be upfront on it, that I don't see it as bad as pedophilia with wood chipper implications, but I still say that it's wrong. That's my opinion. But that is not to say he did it because he denies doing it. So let's take a little bit more look at a high level at the fact narrative here that is applying to what I'm talking about. So she says at 16, she was taken on board a tour bus, and that's something that she wanted to do. She was waiting out there trying to get an autograph. She meets Manson. He solicits her age from her, she said, so he knows she's underage is what she's getting at there, and also her contact info. Then she says she was forced into sexual conduct. So that gets into the sexual battery issue. And in theory, even if she wanted to do it, which maybe she did or she didn't, or maybe it didn't happen. I'm talking about her allegations. Even if she'd wanted to do it being under the age of consent, that'd still be a problem for Manson. But she also alleges she didn't want to do it. After that, she stays in some form of contact with these secret 800 numbers, and he calls her, she says, and things. Then a second assault occurs, I think, in New Orleans when she's 16. Then years pass. And this makes this narrative a little bit more interesting. Years pass because, if you're in the boat, this is terrible that he's alleged to have done there. And that's a boat I'm in, by the way, if it were true. That's bad. Now, age 19, she goes around with him and does things with him when she's an adult. Maybe she can't legally drink alcohol. That's a separate issue on the kind of grooming thing and stuff. But in terms of the pure aspect of sexual conduct, she's of the age majority, and she does things with him. And now she says there it's also not consensual. And that, I think, gets into some of these aspects of like these other cases. Well, then what were you doing there? You're an adult at this point. Why would you go back there and do that? And she has an answer for that, which she says she had not recovered from the childhood abuse. She'd started using drugs and alcohol to cope with that. And in that kind of mental state, she was susceptible to Manson's power and celebrity. So you buy that or you don't buy it. So to me, it matters a lot, this first aspect of this case, which also gets into a little bit of the legal stuff later, because to me, the main thing is what happened when she was 16, right? Let's say she'd never met Manson before she showed up at 19 and she gets on the bus and she has sex with him, unless she's drugged out of her mind by him or something like that, what really is the issue there? I mean, you went to him and then you left, right? So it takes this whole narrative for that to be wrong, and in any kind of, provable way that she was there, not of her own free will. And the 16-year-old is the part of that. So I think that matters a lot. Again, Manson denying this stuff. And of course, she says the record companies all along the way knew about all this and facilitated it. And that's the lyrics and the flyers and all those things show that that was the situation. And that's why they should be liable as well. Now, should a record company be liable potentially, or promoter, I guess, if you're the one booking the venue and printing the flyers and these sorts of things? If underage fans are particularly habitually abused at concerts by an artist, not saying that's what Manson did, but I'm saying that the theory of that, I could see some liability there. You're profiting off of it, depending on how you advertise it and depending on how you handle it, et cetera. Yeah, I mean, I think you should have a reasonable sense of responsibility there, morally and under the law, that you're not creating an environment where kids are targeted and abused. I mean, right? So, and if they're not being targeted and abused, that's a different story. But the allegation is they were, and they knew it, and because they were making so much money off of it, they let it go. Well, that's a bad fact pattern, as alleged. They're going to have to defend against that, because to me, if I'm sitting there listening to it, I'm like, well, if they did that, that's bad. Did it happen? We'll have to see. All right, so what are a couple of legal things other than the normal stuff? Obviously, the proof, right? The defense and things that'll be coming, and more evidence from the plaintiff, more evidence from Manson's side. People have said, well, what about AntiSlap? I mean, hey, come on. In the Wood Gore case, they get to stop that case and put it on ice for such a long time under this AntiSlap rule that says because of his speech, Manson's case gets halted in its tracks. So how can this person turn around and use Manson's speech against him? Well, how can she do it? First of all, she's not Wood Gore, so she's a completely different party. She can do whatever she wants. Second of all, it's a different state. So it's different parties in different states. So it's just not the same thing. But that doesn't make your point invalid in terms of a concept. Like if it's good for the goose, it should be good for the gander. I get that. Well, I looked at it and at a first brush anyway, which is New York has an anti-SLAPP law. It was only amended a couple of years ago to put teeth into it. So they do have this anti-SLAPP situation in New York now, and it has some similarities to California. Except here you make a motion to dismiss, and if you do it under this kind of anti-SLAPP formula, it stays the discovery in the case, like California pretty much. And here, if you appropriately invoke it, the plaintiff has to show a substantial basis to continue on with the lawsuit. That, in theory, means more than it does in California in terms of having to proceed, a tougher situation for the plaintiff. And it's also broader than California. It basically is designed to cover anything the statute said except what is a, quote, purely private matter. So in California, you had to have these categories you wanted to fit into to get the anti-SLAPP, and here it's basically anything except purely private matter. But it does say the claim has to be based on the speech, and I think there's some more technical issues here. There's the similarity of the intentional infliction of emotional distress that both cases have, California and New York. But really here, wouldn't you agree that her case is primarily the fact that she was physically assaulted, right? That's the essence of her complaint. And is the speech the basis for that? I mean, it is in part. So I haven't researched this enough to know, but if Manson's team does and they find the law to support it, I could see them bringing in an anti-SLAPP motion themselves, because there are speech elements in the lawsuit that help her establish what her claims are. And they can say, hey, this is protected conduct under the statute, and test it early. I don't know that I can't say this with any certainty because I just looked at it yesterday and I didn't have much time to look at it. But that's what I found out. They have a new statute, relatively new. It's kind of tougher than California in terms of being favorable for the defendant, which here is Manson. So your point about can he use it? Yeah, he can, as long as the law supports using it. He certainly can, and he may in this case. Another situation that's a little interesting here, and somebody said, well, what about this? Which is jurisdiction and applicable law. So if she's assaulted in Texas and New Orleans, why is this lawsuit in New York? That's a good question. So some of the things happened in New York, and that's how she brings New York into the equation. She said she was assaulted in New York. So when you do a bad thing in a state like that and commit a crime or a tort or something like that, you can be subject to the jurisdiction of that state, even if you don't live there. So I think that helps with that. They also have to have subject matter jurisdiction, and she's got it in the right court for that. I mean, she's in the court that will hear torts like this. But what about this Texas and New Orleans stuff? Well, you can hear that there too, okay? The question really is whose law applies? So when New York court looks at it, do they say, well, this assault occurred in Texas, I'll evaluate it under Texas law, under the tort law there. That's the standard of behavior you both guys were operating under when it occurred. We'll adjudicate it here, but I'll test it under that law. Or do they say, yeah, it happened there, but you're in New York and you're under New York law, baby? It can go either way. It can go either way. New York, when I started to research it, was using a center of gravity approach to torts, saying that if the center of gravity really was New York, then they would just apply New York law and keep it simple and keep it real. It's their courtroom, their law. So it can kind of go either way. Andrew Burkhart brought this up before I did, and really before I was really even thinking about it in terms of whether it's an issue or not. So I don't have a firm opinion on this other than obviously probably the plaintiff's attorneys looked at this pretty carefully and would try to make a complaint that it's going to get past the motion to dismiss. That's usually what happens. Sometimes they fail. So I'm putting the odds in the favor that they've got a good argument that they're going to claim center of gravities in New York. Some of the assaults occurred there. They all should be judged to the standard of conduct that they have in New York because they're all kind of the same pattern of conduct. The same things were happening everywhere. We'll see if that's successful. And then I'll be interested if Andrew doesn't have time to research it, what she comes up with on it, because the law can bring you some surprises in this area. And I have not found all the Easter eggs on this topic, but I did want to at least touch on it. And maybe we'll know some more answers to that by the end of the week. So that's my notes on this case. Bottom line, I think it's pretty serious because it involves allegations against a minor. At least we have an early response on this from Manson, which says, no mystery here. I didn't do this stuff. So anyway, Manson has had obviously a good run with several of these cases. Now he's facing another one. Could there be more? Yeah, because these states keep changing these laws and old cases can be filed. I mean, just watch the news. They're getting filed all the time. I don't know whether that'll happen or not. But as to this case, it's relatively significant. I know some Manson supporters have said this person, they know who she is, they believe, and I think they're correct, has given accounts in the media before that aren't consistent in some ways with what she's saying in this lawsuit. Okay? Fair point. And she'll need to account for that. And maybe she can and maybe she can't. I've read at least some of it that people have provided me, so I've got an idea of what people are talking about there. So we'll watch as the facts develop and the core issue of whether this stuff happened or it didn't happen. Thanks, bye.